Subsection 1, Application of Payments. Article 1252. He who has various debt of the same kind in favor of one and the same creditor may declare at the time of making the payment to which of them the same must be applied, unless the parties so stipulate or when the application of payment is made by the party for whose benefits the term has been constituted. Application shall not be made as the debts which are not yet due, if the debtor accept from the creditor a receipt in which an application of the payment is made. The farmer cannot complain of the same unless there is a cause for evaluating the contract. Is the designation of the particular debt being paid by a debtor who has two or more debts or obligation of the same kind in favor of creditor to whom the payment is made. Article 1253. If the debt produce interest, payments of the principal shall not be deemed to have been made until the interest have been covered. Interest must be paid first. Obligatory. Effect if payment is credited to the principal. Deduction of principal. What is the interest is supposed to be paid? There have two. Interest by way of compensation and interest by way of damage due to default. Article 1254. When the payment cannot be applied in accordance with the preceding rules or if application cannot be inferred from another circumstances, the debt which is most onerous to the debtor among those due shall be deemed to have been satisfied. If the debts due are the same nature and burden, the payment shall be applied to all of them proportionately. In cases of multiple debts, to determine the onerous of the same, the following may be stated as basis for such determination to wit. Number 1. In the event that one obligation is principal in nature and the other one is incurred as surety to another, the former is more options. Number 2. Where there are various debts, the oldest ones are more burdensome and payment shall be applied to them before the most recent ones. Number 3. The debt that earns interest is onerous than the debt that does not. Number 4. The debt with security is onerous than that of having none. Subsection 2, Payment by Cession. Article 1255. The debtor may cede or assign his property to his creditor in payment of his debts. This cession, unless there is a stipulation to the contrary, shall only release the debtor from the responsibility for the net proceeds of the thing assigned. The agreements which on the effect of the cession are made between the debtor and his creditor shall be governed by special law. Payment by cession is another special form of payment. It is assignment and abandonment of all the properties of the debtor for the benefit of his creditor in order that the latter may sell the same and apply the proceeds thereof the satisfaction of their credits. Subsection 3, the tender of payment and consignation. Article 1256 is the creditor to whom tender of payment has been made refuse without just cause to accept it. The debtor shall be released from responsibility by the consignation of the thing of some due. Consignation alone shall produce the same effect in the following cases. Isa niya dito yung when the creditor is absent or unknown or does not appear at the same place of payment. Number 2, when it is incapacitated to receive the payment at the time it is due. Next, when without just cause refuses to give a receipt. 4. When two or more persons claim the same right to collect. 5. When the title of the obligation has been lost. Article 1257. In order that the consignation of the thing due may release the obligator must first be announced to the person's interest in the fulfillment of the obligations. The consignation shall be effectual. It is not made strictly in consonance with the provisions which regulate payment. The purpose of the announcement is to give the creditor the chance to accept the tender of payment and avoid unnecessary litigation. The article emphasizes on the fact that consignation must be strictly made in consonance with the provision of the law in order for it to be effectual or valid. Article 1258. Consignation shall be made by dispositing the things due at the disposal of judicial authority before whom the tender of payment shall be proved in a proper case, and the announcement of consignation in other cases. The consignation having been made, the interested parties shall also be notified thereof. The distinction between tender of payment and consignation. Basis, nature. The tender of payment, it is the antecedent of consignation or preliminary act to consignation. In the consignation, it is the principle of consummating act for the extinguishment of the obligation. Effect, tender of payment, it does not by itself extinguish the obligation, the consignation. It extinguishes the obligation when declared valid. Character, tender of payment, it is the extrajudicial, and consignation, it is the judicial, for it requires the filing of complaint in court. Requisites of consignation. Number 1. Presence of existing valid debt which is due. Presence of prior valid tender of payment. Proposal of creditor to accept amount or thing tendered. Presence of prior notice of consignation. Actual deposit of the amount or thing in court or competent authority. And last, second notice after the making of the deposit is mandatory. Article 1259. The expenses of consignation, when properly made, shall be charged against the creditor. If the consignation is properly made, the filing of the suit must bear the expenses of consignation like storage fees, filing fees, attorney fees, and other related expenses. Article 1260. Once the consignation has been duly made, the debtor may ask the judge to order the cancellation of the obligation before the creditor has accepted the consignation or before a judicial declaration that the consignation has been properly made. The debtor may withdraw the thing or the sum deposited, allowing the obligation to remain in force. Effect of valid consignation. When the consignation is properly effected, the court will order the cancellation of the obligation upon motion duly filed by the debtor. When the validity of the consignation has been affirmed by the court, the consignation shall have a retroactive effect. The obligation is deemed paid from the moment the amount or the thing due has been actually placed at the disposal of the court. The running of interest is stipulated is also deemed suspended at the same time. Last, Article 1261. If the consignation have been made, the creditor should authorize the debtor to withdraw the same. He shall lose every preference which he may have over the thing. The co-debtors, guarantors, and sureties shall be released. Effect of withdrawal with authority of the creditor. Since since consignation is for the benefits of the creditor. He may authorize the debtor to withdraw the deposit after he was accepted the same or after insurance of the court cancellated the obligation. The co-debtors, guarantors, and surety shall be released from the obligation. The solidary debtor shall be released only for their solidary liability but not from the share of the obligation. Thank you.